So welcome everyone to our webinar with the Vermont Law and Graduate School and presented by the Vermont Small Business Development Center through our partnership in the Community Navigator Pilot Program, which is a statewide effort to connect business owners with what you need to start and grow your businesses. This program is funded in part by the Small Business Administration. And as we get going, I just want to go through a little bit of the technical and logistical points for this webinar. We will be turning on live captioning, and keep in mind that this is generated by artificial intelligence. So there may be a few typos here and there, so please forgive those. We are recording this session, and we will email that recording to you or have it on our website so that you can watch it on demand at any time. And we ask that you please use the chat to ask questions. Our presenters today will use that chat to monitor questions and may interrupt their presentation as they go along to answer them in real time. And so with that, I'm going to hand it over to our friends at Vermont Law and Graduate School.
Hi, everybody. Thanks for joining us. Topic of this webinar is going to be how businesses can deal with risk as they're doing business and how they can increase their security. So let me go over the agenda real quick. We're going to cover a variety of topics. We're going to cover 4 major areas of risk that businesses typically face. We'll talk about what different business entities owners might select from to protect themselves against risk. We'll look at what it looks like if an activity is actually putting the business at risk. What does that look like? And we'll look at what happens if something goes wrong. And then we're going to go over some useful tools that businesses can use to protect themselves against risk. We'll talk about insurance, waivers, consent forms. We'll talk about labeling. We'll talk about what goes into a good contract. And then we'll finally touch on a related topic, which is a hold harmless or indemnification agreement. So, brief overview here of the 4 different kinds of risks that businesses face. Before we get into more specifics, we just want to make sure that you have a high-level understanding of some of these areas. I'm going to go over these, and then we're going to come back to them over the course of this presentation. What is a tort? A tort is a pie. It is also an area of law that lawyers lump a lot of different injuries into. A tort is what happens when someone or something gets hurt. There's a few different kinds of them that businesses need to be aware of. Ordinary negligence is a legal claim that someone did not use ordinary care and that it hurt someone or something. So an example is a basic slip and fall accident or a car accident. Someone didn't mop up the spilled water and a customer got hurt, or someone wasn't paying attention and rear-ended your car. Very common claims, and it's reserved for usually mistakes and accidents. There's a difference between ordinary negligence and what is called an intentional tort. An intentional tort is where someone intended to hurt something or intended to do something that hurts someone. So an example might be someone pushing another person causing an injury. As you can imagine, the consequences for intentional torts are a little different than for ordinary negligence. Somewhere in between negligence and an intentional tort is gross negligence. This is something that's reserved for when there's a higher standard of care, like some of the licensed professions, like medicine or the law or nutritional counseling, for example, or it can be reserved for when someone is just reckless about a safety standard. For example, a gym owner who doesn't provide a defibrillator and sells memberships to folks with heart problems. Malpractice is a different kind of tort. It's a subcategory of negligence that's reserved for licensed professionals who have a heightened standard of care, like doctors, nurses, and lawyers. If someone who's in one of these regulated professions has a license, makes a mistake, and causes an injury, there might be a malpractice claim. And then another kind of tort to be aware of is related to products that a business sells. It's possible for manufactured goods to cause injury to someone or something. This can happen, for example, if there's a faulty design to a product, maybe a toy that's sold to infants that has small parts that can choke the child. It can also happen if there's a good design, but the manufacturer makes a mistake when it makes the product. For example, a can of soup that shows up with metal shavings in it. That's happened recently in the news. Another area of liability for businesses is contracts. This is a basic contract is someone agreeing to something. This applies to ordinary contracts where there's goods or services that are being exchanged. This is a common area of risk. There's also an area that's within contracts known as consumer fraud. It's also known as overpromising. If a customer is reasonably misled by a promise that a business makes in a contract, they might have a claim that the promise was fraudulent. And consumer fraud can include something as simple as a contract to provide a product, or even just someone purchasing a product that was overpromised for a result. There's another kind of license of contracts that come into play for folks who are in the creative industries or who are using materials that someone else produced. There might be an agreement to license other materials, or folks might have a contract with other people to use their own materials. And of course, businesses have to enter into debt, usually as part of their ordinary course. Whenever a business signs an agreement for a loan, that business is going to have to pay the loan. And if an individual owner signs a guarantee for that loan, then the individual owner might have to pay it too. Another area is regulations and licensing. This comes into play when someone needs to get permission to do something, or they were supposed to register for something. So examples are a town permit, Act 250 permit, an A&R permit. You could also look at registration with the state to be an LLC, for example, or a corporation. Failure to register, failure to get a permit can sometimes cost a business. And finally, taxes. Taxes have to be paid. The government must be paid. There's a couple different types of taxes that businesses encounter: state, federal taxes, and employee withholdings. And as we'll discuss in a bit, taxes are something that have to come first, because failure to pay taxes can cause everyone in the business a lot of grief. So I'm going to hand this off to Mary. She's going to cover basic business entities that a business can select from.
Hi, everyone. So this is an important topic because the type of business entity that you choose depends on whether the owners of the company are going to be protected from liability. So the business entities that can protect you are known as limited liability companies. Those include LLCs, corporations, and LLPs. Sole proprietorships and partnerships are not limited liability entities, meaning they cannot protect the owners from liability. They cannot protect the owner's personal assets from liability. Entities with limited liability have a liability shield. This protects the owners from personal responsibility for the business's debts or liabilities. But as we will learn from the next slide, the limited liability shield is imperfect and cannot protect against all forms of liability.
Yeah, they are not bulletproof. So even if you have an entity that's set up, there are ways that entity is not going to necessarily protect against all damages. So I'm going to hand it back to Mary. She's going to talk about ways that a business can anticipate risk and protect against problems.
So these are the various risks that businesses might face, and I'm just going to jump right into torts. So in tort law, respondeat superior means the master must answer in Latin. This legal doctrine means that the employer is legally responsible for the wrongful or tortious acts of an employee when the employee is working within his or her scope of employment, or in other words, within their job description. Manufacturing liability is also called products liability in law. In products liability, a person is liable when the consumer proves that the product is defective, regardless of the person's intent. In other words, the commercial seller of a defective product that causes injury will be liable for the injury caused. And the manufacturer will also be liable because in this area of law, all parties along the chain of manufacturing will be liable. So it doesn't matter if you're the manufacturer or the seller. It doesn't matter if you get it from the company, when you get it from the manufacturer, if you sell it and it is defective, you will be liable. In contract law, contracts create an agreement between two parties, creating a mutual obligation enforceable by law. When a company representative, regardless of their role in the company, acts within the scope of his or her actual or apparent authority, he or she creates a legally binding obligation on behalf of the company. Such authority can be established through direct evidence or can be implied through the actions of the others at the company. For example, a member of a member-managed LLC may bind the company by signing an agreement on behalf of the LLC in the ordinary course of the company's activities. Unauthorized individuals, say someone working in the mailroom, are individuals that can potentially bind the company, meaning the organization must be clear with their internal policies on signing authority. And that means who can sign contracts that will bind the company. It comes down to who has the authority to bind the business, or who looks like they have the authority. When it comes to overpromising, the next topic, it is important not to make specific promises for specific actions, because overpromising and underdelivering can lead to a claim that was fraudulent. Manufacturing and consumer frauds will not only ruin the reputation of a company, but can also bring legal issues. The Federal Trade Commission and the Attorney General's office regulate deceptive marketing and contract law surrounding overpromising and underdelivering. The consequences are pretty steep with heavy fines. Businesses can protect themselves by not giving out specific promises. Instead, it can be helpful to use fluffy language that doesn't make a specific promise. An example of this might be claiming that a particular tea company can help when you're recovering from heavy exercise. And the fluffy language version of that would be, rather than claiming that the tea will restore your energy after a workout in 10 minutes flat.
Actually, I'd reverse that, Mary, because the fluffier language is saying, oh, this can help you recover from exercise. But the specific promise that might lead to a consumer fraud claim would be a specific claim of, oh, this is going to restore your energy after 10 minutes of drinking this tea.
Thanks, Professor. So taxes are a version of direct liability. Any person in the company who is required to collect, pay over, or financially account for taxes paid to the IRS may be held liable for the failure of payment. This is a direct liability, meaning it goes straight to the owner or the responsible employee who is supposed to properly file the taxes. As for regulations and licensing, this is also direct liability. For licensed professionals, this is typically tied to the individual who failed to get the license, but sometimes can hit the business as well. For regulatory requirements and registration, the liability usually goes straight to the owner and the business for failing to take the required steps for regulations.
Thanks, Mary. So I'm going to hand it off to Kate here. She's going to talk about what does it look like and what happens if the company, what happens to the company and the owner if something goes wrong.
Hi, everybody. My name is Kate. Excuse me. Thank you for joining us this afternoon. And yeah, what happens to the company if something goes wrong? Well, the owner is vicariously liable for the employee's actions under certain circumstances. So what does vicariously liable really mean? Sort of an example of being vicariously liable is a parent, for example, is responsible for the actions of their child. That's an example of being vicariously liable. And sort of similarly, a business can be vicariously liable for the actions of their employee. Not always, but it's possible. So, excuse me, let's see. An example of this, a real life example, one of my first jobs was working for a florist. So I'll use that example. Let's say I'm a business owner, I own a florist company, and I have an employee that delivers the flower arrangements. And while they're en route, they get involved in a car accident. So in that situation, the business could be liable for the actions of the employee. It was part of their job description to be doing that, and it was during work hours. A different example, if you switch the details a little bit, is let's say same scenario, but the employee decides while they're out on the delivery, oh, you know what, I need to go to the bank and do some personal banking. And they go through the drive-through window, and the truck hits the roof of the drive-through and causes structural damage to the bank. In that situation, the business is likely not going to be vicariously liable. It wasn't part of the job description, and it wasn't related to the business in any way. So the details really matter. So other examples are, if the business is vicariously liable, do they have enough insurance to cover the costs? Do they have enough assets within the business to cover those costs? And the topic of insurance will be coming up following this part of the discussion. if the business doesn't have enough to cover it, that could end up being that the business owner personally may have to cover that, depending on the situation.
And Professor Goodenough's going to pick it up there and is going to talk about this concept of piercing the corporate veil, which is legal terminology for holding the owner responsible for the debts of the business.
Yes, as you've heard, essentially there's a sort of a series of questions that we ask. The first one is, was some wrong committed toward or some contract obligation gotten, or one of these other considerations we'll see. And then the question is the company going to be liable? And this, as Kate pointed out, that depends in part on whether it was the course of employment or whether the contract was signed with authority. But once the company is clearly at risk, then there's this question of what assets will be applied, and the assets of the company would first be applied to liability and any insurance the company might have. If those are insufficient, now we come to really this next question, and this is kind of the crux of protecting owners, which is, will the owners also be at risk? Will the owners be at risk? And as was mentioned previously, there are these limited liability company that can be put in place, entities, corporations, LLCs, limited liability partnerships that come with a legally mandated shield that sits between the obligations of the company and the pocketbooks of the owners. That said, as previously said, that's not a perfect shield. It's a pretty good shield. It's worth having in most instances, but there is this doctrine called piercing the corporate veil, and these are circumstances where the law will say, hey, we're not going to pay attention to that shield. We're going to just disregard it. We're going to pierce through that shield. And when the circumstances that arise where that arises are typically in either one of two buckets. One is when there is an underattending to the formalities. So if the corporation doesn't have meetings, or if it doesn't keep separate accounts and that kind of thing, that's the kind of place where as one famous judge said, if the owners couldn't be troubled to pay attention to the existence of their company, why should we? So the formalities piece is one. The other bucket is when the company is really used as what's sometimes called an alter ego, where it's basically just in place to do the business of its owners rather than its own business. Again, not enough formalities, not enough separation. So a key element in maintaining that corporate veil is for business owners to actually pay attention to the formalities, have the meetings, sign things in the proper way. Don't mix personal and company finance. Keep that separation going. That's one of the best ways to do that. Sometimes also the veil will be pierced if there's fraud of some kind. Again, that could take many different kinds of formats, but the court is not going to be interested in maintaining that if there's fraud. Can I give
there's a question? Yeah, sorry, you saw the chat question.
LLC being pierced. LLCs the veil is a bit more durable, partly because as the law says, LLCs have fewer formalities, and therefore there are fewer instances where a failure of formality would be a problem. They don't have mandated meetings the way corporations do. That said, if the business owner, say it's a solely owned LLC, or there's only a couple of partners, if they mix their money together, again, have only the one account, or hold themselves out without mentioning the LLC and as doing business sort of in their own account, or commit some kind of fraud or other piece like that, that would be the kind of circumstance where an LLC would be disregarded. Again, the formalities, as I will just keep pushing this idea. Make sure that the formalities, that the LLC is treated as its own company with its own things and with properly identified as the entity doing business. If people are careful about keeping track, that reduces the risk of this piercing considerably. Does that answer the question adequately?
Yes, it does. There's some special considerations too. So the owners can sometimes be the bad actor themselves.
Yeah. This is that said, all of that said, owners can create their own problems for themselves too. This is Kate was saying, if there's an accident with that floral truck, if the employee is driving it, that's one set of considerations. Suppose the owner's driving it. The fact that they've got an LLC doesn't absolve them if they're the ones who were negligent and banged into things and caused damage. So again, individual actions by an owner can cause this. There are also other circumstances where the owner can be at risk for their own actions. A failure of regulatory compliance, for instance, can give rise to liability, not just at the company level, but also at the level of the person who should have complied and didn't. And again, if that's the owner, that's an area where their own liability will be there. Taxes, as was mentioned, the government isn't keen on being ignored. So they basically say, yeah, okay, you've got a limited liability shield, that's cool, but you actually paid no attention to paying the taxes when you should have. Therefore, you're liable yourself for that failure, and they will come after you potentially. Small businesses that get in trouble sometimes think that one of the easiest things to do is to not pay the Social Security taxes rather than not pay their vendors. And the answer is that may be true in the short run, but that's going to come back and bite the owners in the long run.
It can also bite the officers and directors.
Yeah, exactly, the officers and directors, anybody really involved in that. I've got a personal story where I got sent a claim for $40,000 by the Vermont Department of Taxes for and luckily it was not sent, but it was because I was a director of a nonprofit, and they thought the nonprofit owed some of these employment taxes. Luckily, we didn't, but again, I myself have had that moment when that tax bill arrives.
Not a happy moment. The consequences for when something goes wrong, there's a wide variety of things that can happen. So there's obviously the potential for a conflict, which can resolve in a lawsuit. It can resolve outside of a lawsuit as well. But lawsuits are often a way of addressing claims and differences. There can be an insurance claim. Obviously, insurance is there to protect and to pay some of these claims, but businesses should also be hesitant to overuse their insurance, because more claims that are submitted under an insurance policy, the more expensive the insurance policy, drives up the cost. Regulated professions, again, doctors, nurses, other professions that have a license requirement, they may be subject to malpractice. That could be a claim that's made if they haven't met the standard of care for that profession. If there is some sort of a judgment or a consequence, there could be a lien or an attachment to an asset of the business, or possibly a lien or attachment to an asset of the owner. If the owner signed as a personal guarantor, it can go through and attach to their assets. I've seen owners that have had their personal home attached to for a debt of the business because they signed as a personal guarantor, and possibly also if that corporate veil is pierced, the owner might be held responsible there too. There is the option of dissolving the company, dissolution, splitting up the company and distributing the assets. That can sometimes be a consequence. And then bankruptcy. Bankruptcy is an option for businesses that get into deep to debt or can't pay their vendors or their bills. Two kinds of bankruptcy just to be aware of. There's liquidation, which is where the assets of the business are gathered and sold and creditors are paid. There's also another kind of bankruptcy that allows the business to restructure its debts. The debts are consolidated, they're reorganized, and at the other end, whatever the choice is, the other end is a clean slate for the business to hopefully continue to do its business. So we're going to go over a couple of different tools that businesses can use to protect against risk. Hopefully you all have an understanding of what it looks like. Now we want to help you understand how to protect yourself. Most of the time, an entity shield is going to hold up, but we have mentioned that it's not bulletproof. It's there, but you do need to understand how it can go wrong and what you can do to prevent liability. So here's a few tools. We're gonna hand this off to Stephanie, who's going to tell us about insurance and the different kinds of insurance that can apply to a business.
Hi everyone. As Professor Killoran pointed out, one of the tools to protect against risk is insurance. Insurance sits on top of the whole scheme. Like car insurance, certain insurances protect businesses, including owners, employees, employers when things go wrong. Talking to an insurance agent would be a great free resource. Asking the agent about what type of insurance, amount of coverage, type of insurance, coverage limits, deductibles, exclusions, and the like would help you understand your business's best practices. Generally, there are 4 types of insurance limiting liability. General liability insurance covers personal injury claims like injuries by slip and fall, falling ice, equipment use, and driving. Professional liability insurance covers you for damages resulting from professional malpractice. Errors and omissions referred to as E&O insurance protects mistakes in operating a business, including negligence, errors in services given, omissions, misrepresentation, or violation of good faith or fair dealing. Workers' compensation insurance protects employees and employers and covers their medical costs and lost wages for work-related injuries. There is only limited insurance for tax problems. So through insurances, businesses or owners may avoid being used for malpractice and other tort or contract claims. They may also recover litigation costs, attorney fees, court costs, settlement costs, depending on the types of insurance and coverage.
Yep. There's a couple other tools too that are in the contract realm, and Mary's going to cover those. These are some of the defensive tools that you can use.
Hi again. So I'm going to discuss waiver and consent forms. If a customer might get hurt or your services might hurt someone, a signed liability waiver or consent form can protect the business. But of course, those are not bulletproof, and we'll discuss that as well. So total waivers. Total waivers attempt to protect the business from all liability for injuries that could occur during the course of business. They're very common, and we all probably have seen one. They say something like, I hereby release, waive, and covenant not to sue the company. In other words, whatever happens, businesses are not responsible. However, these are frowned upon and hard to defend in court because they're so broad. Waivers should lay out all of the potential risks involved with the service and make the customer assume those risks. This is a legal doctrine called assumption of risk. By assume, I mean that the consumer understands the risks and shows that they understand the risks. For example, the business owner can make the consumer assume the risks by having them initial each clause of your waiver, or even going as far as reading the waiver out loud to them. So moving on to negligence waivers. Negligence waivers protect the business from ordinary negligence or failure to use reasonable care, which is negligence. These should be written using the principles I just described, which means they aren't broad and that they encompass all of the inherent risks that could be potentially happening with the service. And these do not protect against what's called gross negligence or a failure to use proper safety standards. A good example of this is a gym who allows elderly persons to come and work out, but they do not have a defibrillator in the gym. So moving on to consent forms, these are forms often used in the medical field, and this depends on the accurate and clear description of the possible results, complications, and risks, whether or not these will hold up, or whether these should have the clear description of the possible results, complications, and risks. These try to show that the patient understands the inherent risks of the procedure, and this can also include having them sign and initial all of the clauses to show that they understand the inherent risks that go along with the medical procedure. And these should be worded carefully and must be specific enough that the customer understands that their injuries might be there. And Professor Killoran is going to take over.
Did you want to add anything to that, Professor Goodenough?
If I might briefly, yes, as Mary has pointed out, the waivers can be helpful. They are not universally enforced. What happens is that courts will generally implement agreed bargains between parties in the United States. That's a general rule, but they also do not want to excuse outrageous behavior or behavior that where there's an imbalance, where somebody knew about dangers and just said, "Oh, come on in and sign here." So again, as Mary pointed out, these can be very helpful for a business to have these, but they are not a magic pill to prevent liability. In this is a context where getting legal help around how far a waiver can go is a very useful piece, because they will not immunize a business if it is creating inherently dangerous circumstances that the customer wouldn't necessarily be aware of.
Yeah, waivers they're not perfect, and they have to be worded very carefully. And that's another area where it's very useful to take a waiver and take it to an attorney to say, is this going to protect against the risk that my business faces, and how should I word it to make it more effective? Safety standards. That's another area where business can point to something that says, look, we tried to prevent harm, and it can sometimes protect a business. So safety standards look like posted warnings that say, you know, this is a potential risk, watch out. That's what a wet floor sign is. It's a posted warning. Employees can be trained, and by the way, employee training should be documented to show that the business tried to show employees what to do, how to do it, and how to do it safely and prevent problems. Employers should have standards and procedures on hand and readily available to employees to tell them what to do and how to do it. That's another form of documentation. And then businesses can post disclaimers, or they can include them in their materials so that customers can understand the consequences. This often shows up on websites, you know, a statement that specifies or places limits on a business or an individual's legal liability. And then finally, another area is labeling. This is what folks who produce products are going to pay attention to. So labeling can prevent liability and protect against risk. There's some types of products that have specific labeling rules. So as you can imagine, food products have specific labeling rules. It also includes the nutritional supplements and children's toys. A label is a kind of warning that tells the customer, watch out, something could go wrong, something might go wrong. And this is how the product should be used appropriately to prevent injury. Just like a waiver, a label needs to be phrased very specifically, but carefully enough to warn the customer of what could go wrong and to be clear about what the consequences should be. Labels must be readily understandable as well. They have to be written in plain English. And then just contracts in general. I'm going to hand this off to Stephanie so she can talk about what goes into a good contract and what different kinds of terms businesses ought to just look out for when they're looking at contracts.
A contract for goods and services spells it out what's going to take place into words. Contracts are a meeting of the minds between parties and are all about making sure that both parties understand each party's goals, rights, and responsibilities. Some basic terms of a contract are scope of services, who does what, ownership of materials, who owns what materials, standards of work, like what is acceptable work and what is not, term of an agreement, how long will the agreement will last, delivery deadlines, who will deliver what, when, and responsibility for like missed deadlines, fee schedule of a payment, how much will be paid and when, and frequency of invoices, expenses, who pays for extra costs, and termination provision, indicating like how to end the agreement and what happens if it ends.
And then there's another kind of, there's another clause that sometimes goes into contracts. This is something that businesses should be aware of because sometimes a business is asked to hold someone else harmless against injury that could happen. Go ahead, Stephanie.
And we'll learn indemnification provision. If something goes wrong, this indemnification provision in a contract may impose a duty on one party to pay another party for their harm or loss. And indemnification would address who will make up any damages incurred by a party named in the contract or a third party, and who will be responsible for addressing these matters. Commonly in the production or manufacturing agreement, indemnification provision indemnifies the producer against product liability if there is any manufacturing defect. Commonly in service agreement, this provision indemnifies the coordinator against tort or contract claims of the third-party service providers. Besides contractual agreement, there is also statutory protection of indemnifying officers and directors. Indemnification statutes allow the company to indemnify directors or officers, and they may recover defense costs, including litigation fees and attorney fees.
Did you want to add something to that, Professor Goodenough?
If I may, yes. Conceptualizing an indemnity is a little bit, it can be useful to think of it as a kind of private insurance policy that's put into the contract. Basically, one party says to the other, hey, I will pay your damages, including potentially the litigation expenses, if there is a problem with X. Typically, X would be something that would be in my power as the manufacturer or as the handler or whatever to have prevented. So if it's in my power to make a safer product, I may be asked to indemnify the purchaser for damages that flow from faults with that product. And this wouldn't just be damages to the other party, but would be damages to third parties. So hence the kind of private insurance policy. These are great to receive if you're on the receiving end of them in a contract. They're risky to give because you have just gone into this sort of limited insurance policy business. And as Stephanie pointed out, the officers and directors frequently will be agreed to be indemnified by the company for acts. They cannot be indemnified for criminal or intentional acts typically, but a simple negligence perhaps is something that they can get the company to help them with. And in an age of litigation against directors and officers, sometimes this is a useful backstop in addition to the E&O insurance that they would otherwise receive.
They're called hold harmless agreements. That's the common understanding of them, because you're holding another party harmless for the damages that might occur. You're standing as a shield in the way. Private insurance. That's a great way to think about it, Professor Goodenough. So those are some of the common ways that businesses can protect themselves. That is actually the end of the presentation, and I would love to take a couple of questions if anybody wants to pose them. People are welcome to also raise their hand or turn on their camera and chat. This is an interactive webinar. It's not a chat only webinar, so we'd love to see you if you want to show your face. Kate, you have a question.
I more so, I have a question for everyone, really. It looks like we have some very impressive people here that are listening, some of which have had certifications, licenses, have experience with regulatory mandates, things like that, and as well as like cybersecurity. One little point that I came up with on my research is, like, let's say for a waiver, let's say you have an online waiver and you want someone to initial each provision. What if the person puts in fake initials? Does that void the contract? Does that void the waiver? So I feel like there's a lot of knowledge in the participants that are here too. So I would really love to hear from everyone.
Yeah, that's a good question. Could that be considered a fraud on the business itself, right? Is the business going to be responsible for damages that result to someone who put the wrong initials in there?
Putting the wrong initials in would typically not be a defense by against a claim by the person who did that, because that would be a fraudulent act on their part. What it might do in a third-party context would have to be thought out. But basically, it's a little bit like trying to avoid a credit card charge by putting some fake name at the bottom. It's just not gonna, it's not gonna hold up. So in that context. What you raised, though, is an interesting point about that one of the sources of liability for folks these days, and we didn't focus in on it too directly, is around the cyber connectivity and cybersecurity and personal information and all of that. And that, again, is one of these areas where the way it would track through to an owner is similar to what we've discussed, but it does have its own pieces. And I would just comment briefly on the regulatory one, as is mentioned on the slide. I actually am involved with a early stage business, which is in the financial services area, and that business has I'm its CCO, I'm its Chief Compliance Officer, and one of the things I'm constantly doing is looking at the trainings, looking at the review, trying to do these risk assessments and the risk prevention steps, which are not only good business sense, but also to a large degree mandated by the financial financial company regulation systems that we see, the securities laws and that kind of thing. So again, that's another example of where there's a specialty regime, but that specialty regime needs to then be paid attention to, with both for direct liability of folks involved and for the vicarious liability with respect to owners.
We have a couple questions in the chat, and I think I'm going to ask Nancy to unmute and specify. So Nancy asks, what does the group think about online contract templates? And I'm not clear, Nancy, I think what you're asking about is just a contract you can find online that you can use for your business. Is that right?
Yes, that's
okay.
correct.
Yes, that's correct. So we run into this question a lot because it is businesses might be under the impression that you have to go to a lawyer to find a contract, right? Like a lawyer has to write a contract from scratch. That's not true. Online contract templates can be very useful, but they are a starting point. They should be something that a business picks up and considers and probably should review with an attorney. There are also different sources and different reliable sources. So there can be, for example, industry associations that might have contracts that are more specific to an industry that include provisions that are more likely to be involved in that particular kind of transaction or that kind of service provision. There's the real warning here is buyer beware. So if you find a contract online, it can be useful, but it should not just be picked up and used without being questioned.
And that applies also to some of the online services that will apply this. I've actually have a long interaction with the folks at LegalZoom, which is one of the more famous of these companies. They're smart people doing a good job within the framework that can happen, and that framework is that do it yourself piece. There's minor pieces of electrical repair I will undertake. There are places where I say, you know what, get that electrician in, because this could be dangerous. I would view sort of legal contracting as somewhat the same. One way to be effective in this is to try and see if there is a form agreement of some kind that would be useful across a business's business, and then get the form looked at in consultation with a lawyer, but then not necessarily run every iteration of that form across the lawyer if it's within boundaries that have been set in discussion that way. So there are middle ground between getting everything looked at, getting nothing looked at. Probably the most intelligent is somewhere in between.
We have another question from Sarah. I've heard the phrase mutual indemnification or dual indemnification in contracts. Would you please explain this?
Mutual indemnification, it said?
Mutual indemnification or dual indemnification. Those are, my understanding is they're specific. They're going to be more specific. So it's not just that I'll hold you harmless and you hold me harmless. It's going to be for specific types of damages.
That would be my take on it too. A mutual indemnification would be a circumstance where essentially I would hold my company would hold the other side harmless for fault that can be attributed to my actions. They would do it for a fault that could be attributed to their actions. And sometimes you see that kind of mirror image language in an indemnification circumstance.
Good questions. Yes, Nancy says SPDC advisors always advise clients to review contracts and leases. It's always a good idea.
Yeah. Well,
any other questions?
Mostly a good idea. Again, once you get somebody who's sophisticated in business, if they're a landlord and they're renting out apartment after apartment after apartment, and they're used to the lease and they've educated themselves about what goes into it and all of that, sure, that person would writing up new leases is probably safe. But if something is unusual, etc., having that lawyer that you can touch base with is such a nice thing in that kind of a context.
Any other questions? And I will add too that for at least the next year, we've got funding through the Community Navigator Program so that we can provide 5 to 10 hours of legal services to small businesses who have a legal question that they want. Maybe they got a contract or a waiver or something like that they want reviewed. So while we have those services available, we'd be happy to refer folks on to have an attorney who can look at it for them.
And there are some entry-level criteria on that program that you'd have to meet.
Yes, there are.
Assuming that's met, then we could make a reference on.
Thank you. Sergio, hi Sergio. He asks, any tips or tricks to persuasively convey the benefits of these risk mitigation tools to businesses? Oh, and it scrolled up a little bit. Any tips or tricks to persuasively convey the benefits of these risk mitigation tools to business owners who have operated for a while without many of them and do not believe that there is a positive cost/benefit to it? That's tricky, right? Because you have, especially in Vermont, you're going to encounter this. You have businesses that have been working for quite a long time. They have not encountered a problem. And maybe that's true. Maybe the business is going to be able to continue on and not run into any risk. Some of the ways that we highlight the So some of the ways we address this is to highlight the consequences. So sure, you might be finding 99 out of 100 cases, but it only takes one case for somebody to get hurt and for there to be a serious consequence, an insurance claim, a judgment against the business that can knock the business down and make it more difficult to climb back out. Often individual bankruptcies are filed because of medical debt. Business bankruptcies are often filed because there's a lawsuit or something else that happens because they did not attend to the risk.
And I think it's also, as an advisor, worth being sensitive to the fact that maybe some of these things are inappropriate for a particularized business. I have my own business as a writer and a lecturer and a consultant, and I have not put an LLC in place because I've determined that I'm the only one doing this. If there's going to be liability, it's because I did it. It's not appropriate. I sometimes in my class use the example of there was of a home curtain sewing business. There's folks who do that at their home. What is the potential liability of a home curtain sewing business? And the answer is, one can imagine some far out scenarios, but probably not that much. So again, that would be a context where perhaps some of these techniques could be appropriately ignored. But I think that said, I don't want to undercut our message too heavily, because I think once you get serving the public in a way that could with food, with services, with manufacturing of any kind, now we're beginning to see things that could be a problem. So I would be a little sensitive to folks who are resisting because it might actually be sensible. But I would also try and convince them in circumstances where you really do need that. Would they ride a bicycle without a helmet? Would they ride a motorcycle without a helmet? It's that kind of a question. It's not a problem until you actually have the skid and the accident, and now we need the helmet.
Kate actually asked a question that speaks to this that I wanted to elaborate on. She was wondering if Social Security benefits could be attached if you have a judgment against the business. The Social Security benefits are exempt from garnishment, but if a business has a judgment against it, then that judgment gives the creditor the ability to attach to the bank account. It can give the creditor the ability to have an officer walk in and do what's called a till tap. Open up the till and hand me what's in your till. There are some serious consequences on the other side of a judgment when it comes to collection, and it can include those things. It can include, attaching to a portion of one's wages if it can go to the owner. The consequences are steep, and that is sometimes the best way that we can illustrate to a business why they should take seriously reviewing the documents they use, taking steps to really protect themselves. And to protect others against harm too, right? It's not just about protecting the business. It's about taking steps to make sure that customers understand that something is risky and what could happen.
Professor Killoran, while we're on the subject of personal liability for these things, am I right in believing that holding property in marital property and in the tenancy by the entireties provides some shielding? We might mention that.
It does provide some shielding. It doesn't always, and even in a tenancy by the entirety, there can be an attachment to half of that asset. So it's not perfect. It is generally a greater protection for marital assets, but it still can. It ends up shaking out when there is actually, like, someone attaches a lien to property, and then to collect it, they have to go in and do a foreclosure action on the lien. So in that instance, a defense would be, hey, this is marital property and they can only attach to half of it. But yeah, it's not a defense really.
So some limited benefit from if for business owners married and holding their own personal assets in that kind of a form.
Exactly.
That people sometimes do and at the personal asset level is set up some kind of living trust. Again, if it extends a revocable trust, then the protection of that is probably quite limited. Would that be fair to say, Professor Killoran?
It is fair to say. Generally, I mean, trusts are a pretty good way to store one's assets. They don't necessarily, there are some circumstances where a trust asset can be tapped into for a judgment, but it's pretty rare. The circumstances don't come to mind right now, unfortunately, but it is a possibility. It's just extremely rare. It's generally a pretty safe place to put your assets.
So again, there would be the possibility of some personal level protections. We've talked at the business level, particularly at this kind of thing. There might be some personal level things that people do. I know some friends who've done a bunch of these things. Again, I have not. I have at least judged myself not to be in a high risk personal circumstance, and so I haven't done those things.
Something we haven't mentioned, which I think is important here, is that it's generally not going to be something that a small business really worries about, but if a business is high risk and they have a number of assets that they're concerned about, businesses can sometimes set up multiple entities. One can contain the operations that might be a little riskier, and the other entity can contain the assets of the business. That can sometimes be a way to mitigate risk.
I've seen that done by construction companies that sometimes have a company that owns all the bulldozers and a company that actually does the excavation. It's not a perfect solution again, but to some degree that can provide insulation. Again, there are more advanced techniques that can be talked about in this context. What we've really tried to focus in on here is the sort of the entry level questions of limited liability of a company and how that plays out with respect to the principal risks that companies would be likely to face.
Yeah. Any other questions from our participants? Okay, well, I'm going to advance to the next slide, Sarah, and let you talk about the survey for small businesses.
Thank you so much. And I'm seeing some thank yous come through in the chat. So we do want to thank all of our friends at Vermont Law and Graduate School for your contributions today. We appreciate you and what you are doing to help lift up Vermont businesses through this sharing of knowledge and expertise with us. And before people go, we do want to encourage you to take the small business survey that is part of the Community Navigator Pilot Program. We really want to hear what's working and what's not working for you as a business owner in Vermont. And also for those who attended with us today and those who may be watching the replay, I want to encourage you to connect with us in the Community Navigator Pilot Program. We do have a slide with a QR code that you can scan. And what we like to say is connecting with one of us connects with all of us. There's actually 10 partners in the Community Navigator Pilot Program, and we're working to fill the gaps for resources and connect businesses that may not have been connected to us in the past. So take a look at our website. I also dropped the link to that in the chat. It will be in the video description of our playback, and encourage you to find other resources that we presented, past webinars that we presented with our friends at Vermont Law and Graduate School, as well as what's to come. We've got a lot of things that are coming up with other partners in the Community Navigator program. And with that, I will say thanks again to everyone, and we will see you next time.
Thanks, everybody. I'm going to put up this last slide too. That's got the SBDC contact information and website. And I also encourage any small business owners who are interested, we can provide an educational consult for free. You can also, if you're qualified, do for a paid referral to an attorney for direct services. You do that by going to vermontlaw.edu/CNPP. And you can also see our email address there. So keep in touch.
Thanks, everyone.